Appreciate it. Jack Walker, I've got you here on behalf of the Texas Trial Lawyers Association against the bill.
That's correct.
The Trial Lawyers Association and yourself against the bill. Is that correct?
That is correct.
All right, go ahead.
Thank you, Mr. Chairman. My name is Jack Walker. I'm the president of the Texas Trial Lawyers Association here against testifying against the bill. I would like to pick up on something that Justice Wainwright just talked about. This bill, although it talks about nonprofit health organizations and rural medicine, it has changed to that. It covers thousands of doctors. There's two main public policy reasons why this is bad. Policy. The doctrine of vicarious liability says that an employer is vicariously liable for the negligent act of its employees performed within the scope of the employment. Under this bill, the theory of the bill is because a doctor is performing independent medical judgment that they can't be held liable because the employer doesn't control that independent medical judgment. Take it a step further, and I will just quote you from the case. The appellate court actually addressed this and said not only had the Texas Supreme Court held previously that a neurosurgeon was properly considered an employee of the public teaching hospital under the Tort Claims Act, even though he exercised independent medical judgment. They talked about that argument, the argument of this bill, and said this argument sweeps too broadly. The operator of a motor vehicle, for example, must exercise independent judgment, but it does not mean that he or she cannot be considered an employee under the Tort Claims Act. If you carry this further, an engineer who exercises independent engineering judgment, if the bridge over Lake Austin falls into the water, and you go sue them, and they say, well, the engineering firm says, hey, that engineer was exercising their independent engineering judgment. We can't be held liable. Same with an accountant, same with the trucking. That's bad public policy. The last one that I would like to address, however, is this. This is nonprofit health organizations initially for rural. We've got thousands of doctors. Every person in this room is going to be a patient at some point, and you're going to probably go to a multi-specialty clinic, and they're going to invite you in and say, we want to take care of you. Well, we are full service. We'll take care of any health needs that you have. Think about this. Under this bill, that large multi-specialty clinic that has hundreds of doctors has no responsibility for their doctors. They can hire any doctor they want and have absolutely no responsibility for their acts. Respondeat superior or is about control. They employ them because they can control the doctors. If they didn't want to respondeat superior, just make them an independent contractor. But they don't want to do that. They want to control what's going on. They want to control when they work, where they work, how they work. They want to control what patients they see, and more importantly, what patients they don't see. If they want to have all of the benefits of an employer, being able to control their employee, but they don't want any of the responsibility, this is bad public policy. We'd ask that you vote against this.
Okay, Justice, you get to respond.
Okay, 3 quick points. First, the opinion cited where the Texas Supreme Court confirmed that certain entities can control the medical care provided by physicians is the Merck opinion from the Texas Supreme Court in the early 2000s. Government hospitals in Texas can get involved in the practice of medicine, and that goes to the Texas Tort Claims Act provision of immunity for those judges. Immunity is different from vicarious liability under Section 162. Merck was cited out of context there. With regard to independent contractors versus employees, it is, and I believe it was Chairman Duncan in the legislative history in 2011 pointed out, Swartner as well, that in essence under this structure, the physicians are treated sort of like independent contractors, but the statute says they can be employees so long as they have complete control of the independent medical judgment in treating patients. So the terminology, actually the statute 162, section 162 says the terminology doesn't matter. This is the structure we set up, and without control, the Texas Supreme Court says there can be no vicarious liability, because if an entity has an employee he cannot control, then you cannot prevent any injury that you might be liable for. Control, the Supreme Court quoted, is the supreme test for vicarious liability, and there is none here. Indeed, as the chairman pointed out, it is a crime for anyone other than government hospitals and the physician, him or herself, to control all the medical judgment in treating a patient. And the final point, that engineers and truck drivers could keep their employers from being liable because they're taking care of driving or, the technical engineering practice themselves rather than the employer. Well, the difference is the legislature created this structure, Section 162. The legislature dictated that there shall be no control interference by the NPHO with the physician's treatment of the patient. And the legislature indicated that the Texas Medical Board has to ensure that there are policies and procedures put in place to ensure that the NPHO does not exercise any control. The bottom line, the legislature has spoken. It did not make those same pronouncements for engineers or truck drivers. Those aren't applicable to this situation.
Jack, just one response. With regard to the right of control and what the doctrine talks about. The doctrine talks about control, not control of every aspect, but control of the employee. And I was going to read to you from, in 2024, the ALI approved the restatement third of torts for medical malpractice, and I'll read to you from it. Medical professionals, like other learned professionals, are expected to exercise independent medical judgment without being controlled by lay managers or entities. This does not mean, however, that vicarious liability doctrines such as respondeat superior do not apply to medical professionals who are employed. Instead, respondeat superior applies to employed professionals regardless of the degree of professional autonomy a medical employee retains by virtue of other elements of control that an employee-employment relationship entails. That is what we're talking about here. It's the right to control the employee. If they're going to maintain that right of control under the long-standing doctrine of vicarious liability, if they're going to maintain that right of control, they have to have the responsibility for the employees.
Very briefly, the American Law Institute.
Final word.
Okay, the American Law Institute promulgates the restatements. The restatements are intended to be a summary of the law across the nation, not to tell the states what the law is. And in fact, the Texas Supreme Court has held that the restatement is not the law in this state. The section that you heard quoted isn't even in final form, and it is not the law in Texas.
All right. Thank you both. Thank you. That's actually very helpful. Thank you. Members, any questions for the witnesses? All right. Thank you, guys. Does anyone else wish to testify? No. Representative Hood, ask your questions. Gentlemen, who do you want to ask? Guys? Hey. Sorry. Come back up here. You got a question. He's not a justice anymore. I guess.
I heard final comment and I was walking off. So.
That was my fault.
You're
fine.
You're fine.
It's our fault. Representative Hood has a question.
Thank you, Chairman. And I'm sorry, gentlemen, I missed part of it. I just have one quick question. So I'm reading the unedited 162.0022, and I guess my question to both of you all is this. So if this A1 is added, may not be held vicariously liable, does that involve, I get it if they're not directing them, but what if, is that preventing them if they knew that, I don't know, the doctor was on meth or had an unsafe practice or was overworked? Does that preclude all that as well?
No, and here's why. Just to understand the structure, the NPHO engages the employee, the physician as an employee under the contract. The contract says that that physician shall provide medical care, medical services for the hospital. To perform services, procedures at the hospital, the physician still has to be credentialed. The hospital credentials the physician, does the background check you're talking about. The procedures do not happen at an NPHO facility. They happen at the hospital. That's the basic reason why the NPHOs are basically affiliated with hospitals.
Can I respond?
Yeah, you disagree.
Yes, I disagree. I think the question was if they performed a surgery, for instance, as an employee of, let's say, Doctors Health Renaissance, and they were on meth, and the principals of DHR knew about it. Is that your question?
Yeah, or the doctor, God forbid, is an alcoholic and operating intoxicated and did something bad.
That is classic vicarious liability, and my reading of this bill would mean you could not sue DHR for their vicarious liability for that incident.
DHR is the hospital.
I'm sorry. Okay, Renaissance Medical Foundation.
That was my question. Thank you very much.
Okay.
All right, members, any other questions? All right, you guys are excused now.
Can we?
Continue your friendly walkout.